All right, we'll wrap up Principle 2 on the types of damages that are awarded, and we'll apply them to bar questions. This is the 2013 bar exam where there was a collision between a bicycle and a taxi cab. We discussed this earlier. All right, so to prove actual damages, and we discussed this already a while ago, present evidence that uh, the said amount is the pecuniary damage suffered by the client and that the damages were the natural consequences brought about by the act complained of. You'll have to prove, okay, we discussed that previously. Okay, I will also present damages caused, though not capable of pecuniary estimation. They are to prove moral damages, to prove nominal damages, attorney's fees, exemplary damages, and interest 6% will accrue after the award is given. This is the story about, this is the question about the pregnant woman. Take note. What is being asked is, can she claim actual damages? Yes, she can. But we will answer more specifically for this recording. We will answer this one, damages on behalf of her unborn baby. All right, so here we go. Actual damages. She may also claim compensatory damages. And to answer that question on unborn baby, there's a 2009 bar exam. Because of gross negligence, Y suffered injuries that resulted in the abortion of the fetus. Death of a family member is Y entitled for the death. Uh, this could be a viable answer. Mm, yeah, you could argue this causation, but the facts already say that resulted in abortion, so do not argue against the facts. All right, this one is a motherhood statement. I think under civil law provisions, I think this is the answer. Maybe we can argue on that when we see each other. All right, so here's a 2023 bar exam. Rene and Sebastian, they are enemies. Okay, Rene killed Sebastian. There's a criminal case, and there was funeral expenses, but there was inadequacy of evidence. Still, the trial court awarded temperate damages. Is the award proper? Well, there's not enough evidence. The answer is, when you talk about temperate damages, there is a pecuniary loss but cannot be proved with certainty. That's in 2224. Take note in 2216, no proof of pecuniary loss is necessary in order that moral, nominal, temperate, liquidated, or exemplary damages may be adjudicated. And in the case of Decini, even if 50 million ill-gotten wealth was not satisfactorily proven, because under the rules, the evidence was not enough to prove this fact, the Supreme Court said, well, you cannot find liability for 50 million ill-gotten wealth without complying with the rules on evidence. But the Supreme Court still awarded 1 million temperate and 1 million exemplary damages. So is the award proper? Yes. Based on Decini, based on Article 2224 and 2216. This one, this is a 2024 bar exam. We'll talk about it when we see each other. You may want to analyze this. And that's it for now. We move to Principle 3.